Hi students, the next chapter in business law is Indian Contract Act 1872. Indian Contract Act 1872. It is the act which is passed in the year 1872 and it is applicable from 1st October 1872 to whole of India except the state of Jammu and Kashmir. For what purpose this act was passed? The act was passed to provide justice to the parties entering into contracts. So this is regarding Indian Contract Act 1872. This act regulates the contracts entered by the parties. Okay, what is a contract? Contract is an agreement enforceable by law. This is the definition given in the Indian Contract Act 1872. Agreements enforceable by law. From the above definition, we can divide the contract into two parts. One is agreement and another one is enforceability. So, contract is equal to agreement plus enforceability. Okay, from the definition of contract, we divide the term contract into two. One is agreement and another one is enforceability. What is an agreement? Agreement is the offer of one party accepted by other party. For example, if I am offering my car to a person to sell my car, then it is called as an offer, and if the other person accepted to that, then it is an agreement. Agreement is every promise and every set of promise forming consideration for each other. So, the offer of one party accepted by another party, then it is called as an agreement. Therefore, agreement is offer plus acceptance. Next one is the enforceability. What is enforceability? If there is any problem in case of the agreement, the affected party can go to the court and file a case against the other party. Then it is called as enforceability. To get justice in the court for the contract entered, the other parties can go to the court. That is called as enforceability. So from the above, we can say that contract is agreement plus enforceability. Agreement is offer plus acceptance. Therefore, contract is offer plus acceptance plus enforceability. So from the above, it is clear that contract is agreement enforceable by law. The important terms in the contract. What are the important terms in the contract? Number one is obligation. What is an obligation? It is the duty to be performed in case of a contract. If a person is entering into a contract, he must have some duty. He must do some work for the contract. That is the obligation. It is a legal tie which is imposed upon a definite person for doing a definite act. Example, Mr. X agreed to sell his car to Mr. Y for rupees 1 lakh. In this case, the obligation of X is to deliver his car on getting the payment of rupees 1 lakh. What is the obligation of Mr. Y? To pay 1 lakh rupees to Mr. X. This is called as obligation. Next one is consensus ad idem. What is consensus ad idem? That is, it is the identity of minds in case of contract. That is, the parties entering into the agreement must agree about the subject matter of the agreement in the same sense and at the same time. If there is no consensus, there is no contract. Example is, the parties entering into the contract must understand the contract in the same manner. That is, X have two cars, red color car and white color car, and if he is ready to sell his red color car to Mr. Y, and if Y thinks that he is going to buy the white color car of Mr. X, then there is no consensus, there is no identity of minds, and there is no contract. This is called as consensus ad idem. The next aspect, very very important aspect, that is repeatedly asked in examination is all contracts are agreements, but all agreements are not contracts. What do you mean by that? All contracts, in all contract there is an agreement, whereas all agreements there is it will not be a contract. That is the explanation for this. The above statement, it is true because there are two types of agreements. One is social agreement and another one is legal or business agreements. Social agreements are nothing but friendly agreements. That is, if you are inviting your friend for a lunch to a house, then it is a social agreement. You are friendly inviting your friend. That is a social agreement. It will not give rise to any legal obligation. So it is social agreement. This agreement will not give rise to contract. Whereas legal or business agreement, this agreement is enforceable by law and they are called as contracts. So from the above, it is clear that all contracts are agreements, but all agreements are not contracts, because there are two types of agreement. One is social and another one is legal. Social agreements are not contracts, whereas legal agreements are contracts. This is the explanation to the above statement. Next one is the essentials of valid contract. What are the essentials of valid contract? A contract to be valid, a contract, an agreement which is enforceable by law is called as a contract. If it is enforceable, then it is called as a valid contract. In case of a valid contract, the following essentials must be present. Number one is offer and acceptance. What is offer? What is acceptance? In case of a contract, there must be two parties. One party must offer something and another party must accept to that. This is called as offer and acceptance. This is the first essential of a valid contract. Next one is legal relationship. The parties entering into the agreement must have the intention to create some legal relationship. If the agreement is of friendly nature, then it will not create any contract. Next, third one is lawful consideration. What is lawful consideration? Consideration means the benefit derived by the parties in the contract. For example, if I am selling my house to some person for rupees 10 lakhs. The consideration for me is 10 lakhs, whereas the consideration of that person is my house. So it is called as consideration. Consideration is something in return. It must be lawful. Every agreement must be supported by lawful consideration. This is called as lawful consideration. Next one is capacity of the parties. The parties entering into the agreement must be capable of entering into a valid contract. There is a qualification to enter into a valid agreement. This is called as capacity of the parties. Every person must be competent to contract. That is, they must not be minor. They must not be an unsound-minded person. That is, the capacity of the party is the parties must have some basic qualification to enter into an agreement. They must not be any minor, they must not be any unsound-minded. This is regarding capacity of the parties entering into the contract. Essential to the valid contract is free consent. Free consent is nothing but the acceptance given by the parties to the contract. That acceptance must be given by the party without any compulsion. Without any compulsion, the parties must accept to the contract. That is called as free consent. The consent must not be obtained through any force. That is called as free consent. Next one is lawful object. The object of the agreement or the purpose for which the contract you are entering into must be lawful. That it must not be illegal, immoral, etc. Next one is agreements not declared void. There are certain agreements which are expressly declared void by the Indian Contract Act. If the parties enter into such agreements, it is not valid. Example, agreement with a minor, agreement without consideration. The next essential is certainty. Certainty is the terms of the agreement must be clear, certain and understandable by both the parties. If it is not clear or if it is uncertain and if it is not possible to perform, then there is no contract and it must not be enforceable. Next one is the possibility of performance. The terms of the agreement must be capable of performance. That is, the performance is doing the work in the contract. If the work in the contract, if the person is not able to perform, then there is no contract. Agreements which cannot be or impossible to be performed cannot be enforced. The last essential is legal formalities. Legal formalities is a contract must follow the certain formalities which is legally accepted. That is, the contract must be in writing. Then the contract, or it must be in a written document. It must be stamped and signed by both the parties. These are the essentials of valid contract. The next aspect in this chapter is differences between agreement and contract. What is an agreement and what is a contract? Agreement, first one is the offer of one party accepted by another, that is agreement. Whereas contract, it is an agreement enforceable by law. Second difference is the enforceability of the agreement depends on the nature of the agreement. Whereas contract, it is always enforceable. If it is enforceable, then only it will become a contract. Next one is, it may be lawful and unlawful in case of an agreement, whereas only lawful agreements can become contracts. Next, fourth difference is, when the agreements are illegal, the parties are not liable. If there is an illegal agreement, the parties are not liable because it is not enforceable. Whereas a contract is illegal, the parties become liable. Next one is, all agreements do not become contracts, whereas all contracts are based only on agreements. The next difference is, the agreements created may be social or legal obligations. The agreements create social or legal obligations, whereas all the contracts are based on agreements only. The last difference is, agreement is equal to offer plus acceptance. The contract is equal to agreement plus enforceability. These are the differences between agreements and contracts. The important questions in case of this chapter is, define contract, what are its essentials? It is very important question. It is repeatedly asked in all examinations. Next one is, distinguish between agreement and contract. Next, in 2 marks, they will be asking, what is consensus ad idem, or what do you mean by identity of minds? This is regarding Indian Contract Act 1872, Introduction to Contracts. If you are interested in my videos, you can subscribe to my channel, you can give your valuable comments, and you can like the video and share the video. If you want to subscribe my channel, you don't forget to press the bell button in the comment section. Thank you.